So welcome back, everybody. We go on with our final panel. So from immunity, we now switch to a broad range of procedural topics, more or less procedural topics. And without further ado, because we are obviously a little bit behind our schedule, I will introduce our first speaker. It's a great pleasure to have Judge Rosario Aitala with us here today, presenting on our topic, in particular on jurisdiction. Judge Aitala is judge at the International Criminal Court in The Hague, where he serves as the president of the pretrial division. And in addition, he's adjunct professor in international criminal law at Lewis University in Rome. So it's a great pleasure to have you with us, and the floor is yours. Thank you very much.
Well, thank you very much. To congratulate Florian and Chantal for bringing so many people together. Very, very interesting, and very grateful for having been invited. Now, as we were commenting with Florian a minute ago, the matters under this panel are very, very wide. I'll touch upon a few of them, and I'll focus mainly on the Italian perspective to see what can be accomplished and how and what are the problematic junctures. I will start from an old but still very important essay of Francesco Viganò, and I do believe that Italy must establish jurisdiction on international crimes. Francesco, about 10 years ago, argued that this is connected to the protected interest, to the legal interest beyond the offenses, and especially those offenses which are related to fundamental rights, and which then would probably lead us to crimes against humanity and genocide mainly. I believe he is right. There is a duty for states to establish jurisdiction. There are also a number of conventions, of international conventions, which do establish this duty. The Convention Against Torture, the one on enforced disappearance, the Geneva Conventions with reference to grave breaches, the Genocide Convention, although indirectly. Well, the ICC statute, which also Francesco mentioned in that essay, does not clearly establish a duty, but in the preamble, it does make a reference to the duty of states. And I would say that beyond complementarity, this is one of the fundaments of the ICC. The idea would be, at least theoretically, that the ICC should exist not to be necessary anymore one day to push states to exercise themselves jurisdiction. On top of this, the draft articles 7, 8, 9 of the International Law Commission, which touch upon two different matters. I'll go back to the second in a moment. The first is duty to establish jurisdiction. The other is duty to investigate and prosecute. These are two distinct duties and two very different sets of problems. The second is probably the most acute, brings the most acute problems. Now, Article 7 sets also four criteria for establishing jurisdiction: territoriality, active and passive nationality, and residence, which is very much in line with the Italian criminal code with a number of combinations. Now, as we know, in order to establish jurisdiction on international crimes, we do need a law criminalizing offenses and a law establishing the jurisdictional link. Jerry, in a moment, will tell us about the interesting way in Palermo they've used to prosecute probable crimes against humanity charging ordinary offenses, because there are no other possibility, but probably those were and are crimes against humanity. There are a number of other matters which I leave for the last panel. So how do we get there? What is the rights or the most appropriate model of incorporation Italy can follow, and so on and so forth. I'll go now to matters of jurisdiction, as Ferrara was mentioning, and in particular jurisdiction ratione materiae. Personally, I believe that apart from the core crimes in the jurisdiction of the ICC, we should also look at torture as a discrete crime, which I believe in Sant'Anna they're already doing in their own project, and also terrorism. On terrorism, I know that I'm on a minority. Very humbly, I join my view to that of our beloved colleague and friend Nino Cassese. I believe that things have changed radically since Rome started, since the negotiations in Rome, where essentially 3 points were made. One is that there would be no definition, which Nino would respond to by saying that there is an agreed definition in the Convention for the Suppression or Financing of Terrorism. There isn't an agreement on exceptions to terrorism. The second point was that that was not a crime of concern for the international community as a whole, and it definitely is. If you simply look at the array of resolutions and decisions, especially by the Security Council, the listing, and so on and so forth, and also the political rhetorics, this is probably not true anymore. And thirdly, the idea, the ambiguous idea that national jurisdiction would have been in the better position to deal with terrorist cases has failed dramatically. And this is not only for countries in Middle East and where wars have taken place. I'm talking about Iraq, Syria, but it also relates to European countries. There are European countries, not the case of Italy because we've had a very small number of foreign fighters, but France, for example, is leaving Iraqi authorities to try terrorists with French passports, and this entails a number of problems which we will not touch upon, but I think, frankly, something they should rethink about. So I believe that terrorism should be included. If Italy will go towards this choice, probably terrorism, I believe, should be included also from a practical and, say, the historical standpoint. We do know that a large number of crimes and offenses have been committed in those areas are, if not qualified as terrorism, they're very closely intertwined with terrorism. And this is also triggers another problem, which I'm not going to talk about, and is that I believe also the ICC at the present stage could try some cases not of terrorism as a discrete crime, but of terrorism as form of war crime and crimes against humanity. For example, if European countries would trigger our jurisdiction with reference to their own nationals who are detained in Iraq or in Syria, as it is the case right now. On jurisdiction ratione loci and ratione persone. Now, the Italian jurisdiction has a combination of territoriality, active and passive nationality, and not residence but presence in the territory, ranging from political offenses where there are no conditions, and non-political offenses where the Minister of Justice must have a say, and in addition the person should be in the country. We would probably need to look at one of these combinations. Also, Francesco today was touching on some points. The idea of universal jurisdiction is not feasible in Italy. Very clearly, it's not feasible for another reason, which I'll touch upon before closing my speech, and it's the reason of the lack of prosecutorial discretion. Now, the German, I'm very happy because I had the opportunity of studying the German legislation, which I didn't know well enough. The German legislation has a principle of mandatory prosecution, but with an exception clause at the beginning, unless otherwise provided by the law. We don't have anything like this, and of course it is just impossible politically that the Article 112 of the Constitution could be changed. This is a dogma in Italy. It's a long time dogma. It's very difficult to be touched upon. And I believe that any attempt to introduce international crimes, including this, is doomed to failure straight away. So the first thing in Italy, knowing, having been also at the Senate, knowing how the political mechanism work within the parliament, is making it as simple as possible. If you do include something like this, it's the end of it. So we would never, it would never happen. Now, the German system is quite complex. German law is notoriously very detailed, and it's pretty complex. But at the end, I understand that the prosecutorial discretion is as such to bring to results not that different from those we have in the Italian criminal code, with the difference that you do as a recipient take everything and then make a choice of what you bring ahead. In Italy, we would probably have to make this choice before, because if we take everything and with the important work of NGOs, for example, this would lead to a collapse. And I was very interested in maybe the first panel to hear that in Germany they experience unpreparedness, and you know, if Germans are unprepared, yeah, I wouldn't say what Italians would be. So to be honest, this is really not an option. Well, I promised that I would stop here because we are late. I will complement if there are any questions, and there are a number of practical matters which I would like to fit into the final panel, but more or less I will stop here. Thank you very much.
Yeah, thank you very much, Judge Aitala, for your comments, in particular on the jurisdiction issue. I'm sure we have a few minutes to come back on that later. Just one word on the situation in Germany. The interesting thing is that as a general rule in Germany, there exists discretion if it comes to extraterritorial offenses, generally, not only international crimes, but extraterritorial crimes. And this discretion is limited if it comes to crimes under international law, then it's structured. So that's the basic idea, but I understand the constitutional restraints you may have here. Thank you very much, and please keep your questions and comments, because as always, we will have a round at the very end. So I'm happy to welcome our second panelist, Jerry Ferrara. He is currently European Delegated Prosecutor in the European Public Prosecutor's Office in Luxembourg. But until earlier this year, I understand, and this is, I also understand, important for the topic of your presentation and your input, he served as a deputy prosecutor in the Office of the Prosecutor in Palermo with various charges, anti-terrorism, smuggling, and so on. And I understand that this practical experience is what you will talk about a little bit. Yesterday, already Dr. Mentasti spoke a little bit about some of the cases of the migrant cases, but I very much look forward to your input. You have the floor. Thank you.
Thank you, Florian. Thank you for inviting me, Chantal, all the colleagues here. I want to be clear about that. I'm not an academic, I'm not a judge. So when we study for becoming a magistrate in Italy, they say, study or you became a prosecutor. So I've always been a prosecutor, so I have a problem with that. So this is the reason why my approach will be very practical. And it starts from my practical experience, as you say, in office, like the prosecutor office of Palermo, it was on the front line, especially after 2013, after the increase of the so-called immigration crisis. Why we start to dealing with this kind of crime? Because something happened starting after the war in Libya, after the Arabic Spring, the arrival of thousands of people, hundreds of thousands of people, most of them involving our territory under our jurisdiction in Palermo. As we know, the anti-mafia department has a broader jurisdiction, let's say in the Western Sicily, in the western part of Sicily, so including Lampedusa, including Agrigento, all these areas where thousands of people started arriving and started describing us the terrible crimes that were committed in Libya, that were committed in the Central Africa for the trip of the migrants from Central Africa to Italy to Northern Europe. So when we started hearing that as a prosecutor in charge in an anti-mafia department, that for Italy means also having a jurisdiction on trafficking and smuggling of human beings. And after hearing, as Judge Vigano said, the notizia criminis as a prosecutor about such crimes committed as torture, as rape, as kidnapping for ransom, murder, we received this information. So my idea, my office was, how do we deal with this? Okay, when we have a small crime, an homicide of a mafia homicide, just one people killed. So we put all the power of the states on that, or the investigative measure that as anti-mafia prosecutor we can use. So we have now 360 people dead in the middle of Mediterranean. We have migrants telling us about torture, rape, and so on, and we don't do anything. How is possible about that? But do we have a jurisdiction? We don't have. We know because we don't have universal jurisdiction in Italy, as we already discussed these 2 days. But I think that we could find something to start investigating this kind of crime. According also to Article 112 of the Constitution, say that when a prosecutor has a notizia criminis, he has to investigate those crimes. So our idea was, okay, let's see where it leads. We receive information about torture in Libya, about torture suffered by the migrants when they cross the desert to arrive to the Mediterranean. Let's see what we can do about that. We have these thousands of people giving this information. Clearly, we have a criminal association behind. The criminal association spread its criminal effect from Africa towards Italy, towards Sicily, especially because Sicily was on the front line of the arrival of the migrants. So we have an article, Article 6 of our criminal code, that say that when a crime can be considered committed in Italy, and also when it is committed partially or totally in the territory of the state, or when also part of this, the conduct of the crime is committed in Italy, also when the effect was spread in Italy. There is a very strong case law of the Italian Cassazione about that, especially on the topics of criminal association. So criminal association operating also abroad, when the effect of this criminal association spread to Italy, spread to territory under Italian jurisdiction, so the Italian prosecutor can investigate it, the Italian judge can try this kind of crime, also according to the other article of the criminal code, other two. First of all, Article 10, so when a crime is committed abroad, if a person is present in the territory of the state, if the crime is punished over a certain amount, and also if there is the request of the Ministry of Justice for the authorization. So combining these different principles, and also combining the fact that exactly in 2014, the Italian Supreme Court issued a cornerstone judgment about the fact that also when the migrants were transported from international law to the Italian territory, the fact that the final destination of the crime organized in Africa was the Italian territory, also in this case, there is, and even if this relation is stopped by the intervention of NGOs, or also of the Navy in the middle of international water, also in this case, because in that case there is the need for the people to save human life. Also in this case, is only a segment of that criminal conduct is related to Italian territory, and so in this case it's possible to exercise the prosecutor powers and also the Italian jurisdiction. Is what we did since 2013. I have to tell you that also speaking with a friend of the ICC, we also have a very strong cooperation with them. We have a specific project, was also partially financed by European Union, where we exchange information in a very different way according to Article 19 of the UNTOC Convention, the Palermo Convention. So, but sometimes I tease them, say, look like we are making your job, because we prosecuted in Palermo the crimes committed in the White House torture camp in Tripoli, the Ghetto Valley camp in Tripoli, the Bani Walid prison in the middle of Libya, the Zaia prison or Sama prison in near Zaia, another small concentration camp in Zuara. Say, so what we are doing if we have to do this? We have already our mafia guys, so can you please take care of your international criminals, because we have our local that are already enough for us. But I don't know if they are working on that. Just to give you a clear idea, all these cases I mentioned, all of them until now, where the final outcome was the conviction of all these people. Of course, we could convict until now the perpetrator that we had in our territory, because the head of these criminal associations that are still in Libya, unfortunately, we request cooperation with Libya, also because our idea was, okay, this criminal, we arrest the perpetrator, because most of the time, most of these people, after a while that they work in this concentration camp, they come to Sicily because they earn enough to arrive to Europe and were arrested, were accused by the migrants and so on. But the idea was also to prosecute the head of this criminal association. We have now a change office, but I know that's still ongoing something. We have a few requests pending against them, but of course you need cooperation. As you know, it's not easy to find any kind of cooperation with Libya, because there is a lack of a state, not only a lack of a jurisdiction in any case. But until now, at least the principle and the conviction against the physical perpetrator, we had the conviction in life jail for murder, for kidnapping for ransom, and also in 2018 and 19, we have for the first time the conviction for torture, because the crime of torture was introduced in Italy in 2017 after a long discussion that we have in our system. And for the first time, the court of Messina was an investigation led by the prosecutor office in Palermo, but the jurisdiction was in Messina because the person were arrested there. At the end, first and second instance convicted these people, the perpetrator, the jailers, for torture, for the crime of torture committed in this concentration camp in Zaia. So I think this is in any case, I don't say a success or not, but it's something that as a national jurisdiction lacking the international jurisdiction on international crime or similar, I think is good to share with you.
Jerry, thank you very much for this fascinating insight. I mean, particularly for those not familiar with the situation in Italian, that was really impressive, and I'm sure there will be some questions afterwards to look into more details. Now it's my great pleasure to welcome and introduce Dr. Teresa Magno. She is a criminal judge here in Italy and currently serves as the first assistant to the national member for Italy in the European Union Agency for Criminal Justice Cooperation, so or your Eurojust, as we say, difficult to pronounce in English for me. So a great pleasure to have you here, and the floor is yours. Yeah.
Actually, the pleasure and the honor to be here is mine. I would like to thank in particular Professor Chantal Meloni for the kind invitation. So as it was said, I'm an Italian criminal judge posted at Eurojust, and this is the perspective from which I will outline my thoughts. These thoughts do not engage the agency, they are only my own thoughts. And I will not advertise the agency, I have to make this very clearly, but what I'm going to say is reflects my experience at Eurojust, which is very, very positive from a very practical point of view. And this is why you would allow me to focus on difficulties, issues, but also possible to solutions, even to the issue of mandatory prosecution and domesticating core criminal, core international crimes into the Italian systems. So it's, I mean, from my practical perspective, it's something that could be possible. But I do not want to dwell too much on this. I will talk about this. So Eurojust is competent for cases that involve the most serious crimes, and I will only mention some of them. So terrorism, for example, trafficking in human beings, so migrants, smuggling, and also money laundering, which is very, very widespread. And we also deal with cases of participation in terrorist organizations and kidnapping for ransoms. I've been dealing with these cases when they have involved Italian nationals. And these cases are also brought to Eurojust attention because they require coordination of investigations and prosecutions. And there are several member states who are very much more active than others, and they bring these cases to Eurojust. And these cases involve acts of torture, involves the prosecution and investigation of crimes against humanity. And you see that the Italian prosecution offices deal with ordinary crimes, whereas German colleagues, French colleagues, Swedish colleagues have international core provisions. So this is, so I do not want to criticize anything. This is a very objective, I hope that I can convey you a very objective take on the factual situation. So why do they come to us? Because we can coordinate parallel investigations. We can organize coordination meetings involving the judicial authorities and law enforcement concerned. We can set up JITs. And I will talk about this because this is very, very useful also in international investigations. And we can plan also joint action days steered in real time via coordination centers held at Eurojust, that's in The Hague, in the Netherlands. And we can also provide assistance in case of arrests have to be performed or assets have to be seized. We can facilitate, but when I say we, I mean the Italian desk, but also the EU desks, the desks of the member states that are at Eurojust, so Eurojust as such. So Eurojust can facilitate the swift execution of judicial cooperation instruments. We have huge experience and valuable expertise in judicial cooperation, including a useful set of tools to handle problems such as conflicts of jurisdictions, extradition, admissibility of evidence, which is, you know, for those who work in this field, they know what it means, the freezing and recovery of assets. The operational functions at Eurojust, and experience and expertise in judicial cooperation are very useful also when it comes to investigation, prosecutions, and trial of core international crimes. So we have been witnessing that states are called to manage a growing number of challenging cross-border cases due to the escalation of nearby conflicts. One example is Syria, but you might want to recall also Rwanda, the Democratic Republic of Congo, and Sierra Leone. So this is also due to the influx of refugees, we all know, to the member states. Ongoing crimes may also implicate EU nationals, as for crimes committed by foreign terrorist fighters, but EU citizens may be involved in investigations also as victims and witnesses. So what we have seen is that for an investigation to be successful, it has to be based on a specialist knowledge and close coordination between national authorities. So these investigations are quite challenging, and they require the gathering of evidence across different countries. Most cases requires interactions with third states and international partners as well, as you know. So this caseload that we are witnessing is going up, and it has brought to light also the challenges presented at national level by complex cross-border assignments. And the main difficulties, Jerry, is the example of this, that they have to face when they investigate and prosecute these crimes are linked to the issues of establishing jurisdiction, linking perpetrators with a specific crime scene, gathering evidence, evidence that can be lawfully put before judges, admissible evidence, I mean, and finding witnesses. So you also know that investigators are often restricted from visiting states, countries where crimes are committed or have been committed, which prevents them from locating evidence and interviewing witnesses. So these are major obstacles they have to face. Core international crimes are also frequently linked with other types of crimes, including terrorism, migrant smuggling, human trafficking, and Jerry was talking about this, but also trafficking of diamonds and other natural resources, and especially money laundering. So this presents additional challenges. So in order to try to address these challenges in the most effective and legally possible way, so we have seen that the best solution is to adopt a coordinated approach with national authorities working together, sharing resources, sharing knowledge, and having a unified and possibly consistent strategy. A very clear example I can provide you is of a specific case under the Eurojust that's called the Caesar case. What I'm going to say is public, so I'm not revealing anything secret. This is a very good example of cross cooperation of German prosecution office and French prosecution office in order to address widespread and systematic torture committed by the Syrian regime. And this is a case of 2018. So I will not provide you main information about this case, but I want simply to underline that for these investigations, joint investigation teams are a very good instrument, a very effective tool, because this is a team, the joint investigation team, I don't know whether you are aware of this possibility, which is in the, anyway, provided by the Italian law, but to certain extent. So joint investigation team are set up by mutual agreement by competent authorities of 2 or more states for specific purpose and a specific period of time to carry out investigations. In a similar case, with this kind of charges, I wonder whether we as Italians could have a legal framework that we could provide as legal base for entering in such an agreement, because the JIT is based on an agreement. So I will skip this part, but I would like to convey you that the main takeaway from this is the added value of a coordinated approach with national authorities working together. This is because we have been witnessing the many factual and legal hurdles that can be overcome only by judicial authorities sitting at the same table and addressing practically the issues together. So I would simply like to add to this point that JITs can be set up also to investigate crimes falling within the jurisdiction of the ICC. And I do not see personally any limitations to ICC officials participating in a JIT in a EU nor in Council of Europe instruments. Having said that, I also have to specify that EU instruments allow only competent authorities of the member states to set up a JIT, and prosecutors of international courts can't be considered competent authorities in this regard because we do not have a proper legal base. So briefly, I would like also to make reference to to the Genocide Network, which is hosted at Eurojust, because this is another very useful instrument judicial authorities can rely on. And this is a network of judiciaries, of the judiciary, judges and prosecutors. This network was established in order to enable close cooperation between the national authorities when investigating and prosecuting core international crimes. And EU states are represented through national contact points, and they provide operational support to their colleagues. And this is very, very effective in practical cases. So the network has been addressed and can be addressed, for example, by the OTP of the ICC, in case the OTP is interested to know if any investigation or prosecutions of individuals associated with situations of interest for the OTP are carried out by European Union states. The OTP can also ask, and as already asked, to have checks performed with relevant national bodies in relation to investigations and prosecutions for financial or other crimes related to people of interest of the OTP. As I said, it's a request, which means that it can be declined. This network plays a crucial role. In addition, I would like to mention also the specific usefulness of operational meetings on specific situations or cases, because they can allow a fruitful exchange of information. They can facilitate cooperation and enhance also national investigations and prosecutions, and help to decide at prosecutorial level which state is competent or better placed to investigate and prosecute. And now we come to the issue of mandatory prosecution. It's, in my opinion, yeah, it's an issue. I don't think that it can't be solved. I think that we can draw inspiration from what we are witnessing with Eurojust, meaning that Italian jurisdiction, for example, can be established also when a crime is only partially committed in Italy. So what does it mean? It means that we, yeah, 2 minutes, I know. The risk of overlapping is always there. It's there. But there are instruments to solve it. And okay, I don't want to advertise the agency and our roles, but we are solving it. And people seems to be satisfied with, I mean, the solutions we find. Then it's to the judges, and I'm a judge, so I'm not a prosecutor, I'm a judge. So then it's to the judge to check whether the decision stands or not. But at prosecutorial level, investigative level, and Germany, and especially, you know, it's France and Spain, they send to these meetings where decisions on jurisdictions are taken, they send judges, investigative judges, juez de instrucción. The judiciary is present, they found solutions. If they are not in a position to find a solution, there are also other instruments. And one of them we are making more frequent resort to, it's the Eurojust written recommendations on jurisdiction. So this is a very detailed reasoning on all the factual and legal elements from a EU point of view, but also from a national point of view of all the issues involved in the case. We come to a reasoned solution of the case. Then it's up to the national judicial authorities to follow these recommendations or not. And in most cases, they follow. If they don't want to follow, they have to provide reasoning on the legal, containing the legal arguments why they think that these recommendations are not fit for the case. So solutions are there. And I think that I will stop here. I've very much, I think, exceeded the time that was given to me. Thank you. Sorry.
Yeah. Thank you so much. I apologize for having to be strict on time. No, but thank you very much also for this for this practical insights, and I'm pretty sure we will come back to the issue of mandatory prosecution here in Italy in the discussion. So it's a pleasure to introduce our final panelist, Dr. Triestino Mariniello. He is a reader in law at the School of Law at Liverpool John Moores University in the United Kingdom. And currently, and I'm very happy that this is the case, Alexander von Humboldt Fellow at Humboldt University in Berlin. And Triestino, pleasure, the floor is yours.
Good morning, everyone. Many thanks to the organizer, Professor Meloni, Professor Jeßberger, for the invitation to this terrific conference, and the Alexander von Humboldt Foundation for the support to the organization of the event, and also for the possibility to give that is giving to me to do research at the Humboldt University of Berlin, and of course to live in Berlin, well, to be in East Berlin, to be clear. In line with the title of this panel, I wish to go back to a topic in part touched by the previous presentation, in particular by Judge Aitala, prosecutorial discretion, and in my role as a discussant, try to add a different perspective. As occurred in other countries, including Germany, as Florian was saying before, in relation to extraterritorial crimes, exploring and potentially revising the role and the power of the prosecutor appears necessary every time a domestic jurisdiction plans to introduce ad hoc provisions setting extraterritorial, or to be more precise in this case, universal forms of universal jurisdiction. In particular, one of the key questions I've been asked to address today is when it comes to the domestication of international crimes in countries that establish the principle of obligatory investigation, like Italy, whether and to what extent this legalitate principle should be revised in order to give to the prosecutor more discretionary powers, so opportunity principle, in the decision to start an investigation and the prosecution of international crimes. Of course, this discussion in Italy is possible if we do not consider Article 112 of the Italian Constitution as a dogma. So this general question, of course, would require an entire conference, or even better, a systematic and comprehensive comparative assessment of how domestic jurisdictions, domestic systems have ruled the prosecutorial discretion in relation to the decision to start an investigation and prosecution of core crimes. Well, this is not possible for a matter of time. So in my role as a discussant, I will try to add more food for thought with a view to foster the debate among the panelists and the audience. In addressing this general question or issue, I will propose to look at the ICC practice and domestic experiences, in particular in light of what we heard these days, the German case, as it has been explored in this conference. But just a methodological clarification, I'm not suggesting to rely on an indiscriminate import of other national or international models into another system, in this case in Italy. As argued by Professor Jeßberger during the opening remarks to this conference, our debate today can be informed by the experience of other domestic experiences of other domestic investigation and prosecution and of core crimes. And I would also add, with all the due differences, also by the ICC practice, in light of the common features between international criminal courts and national criminal courts dealing with international crimes. We cannot overlook that this debate on prosecutorial discretion already exists in international criminal justice. It pre-exists to domestication of international crimes, of course. Let's briefly summarize the main reasons used to justify prosecutorial discretion before international criminal tribunals. It is generally held that prosecutorial discretion is an essential element of international criminal courts because of the practical impossibility to deal with all crimes falling within the jurisdiction of international criminal tribunals and because of limited resources. On this basis, it's generally argued that it's necessary that the prosecutor, in particular the ICC prosecutor, has the powers to select situations and cases in order not to overburden the tribunal, well, so the court, the ICC in this case, of course. Scholars also see in discretionary powers the cornerstone of prosecutorial independence, as it would apparently shield the prosecutor from political pressures of states. With respect to the domestication of core crimes. I will leave aside those reasons that are more peculiar to the international criminal justice system, such as the relationship between prosecutorial discretion and independence. In several countries, prosecutors do not enjoy such discretion, but this does not mean that they are not independent. Similarly, the fact that the ICC prosecutor has a huge discretionary power does not automatically entail that he is independent from states that actually elect him. However, at the domestic level, other rationales, particularly those ones concerning the necessity to select among several situations and cases in order not to overburden the domestic jurisdiction in light of the difficulties accompanying the investigation and prosecution of these crimes, are also quite valid, in particular when it comes to universal jurisdiction. On this basis, I would like to make a first consideration for your views and comments. The departure from the legalité principle could be introduced only in relation to those cases that do not present any nexus with the domestic jurisdiction. In other words, cases where the principle of territoriality, active or passive personality are not satisfied, or at least when the suspect is not on the territory of the state in question. These conditions are also present in the several times mentioned Article 153F of the German Code of Criminal Procedure, which also add other two circumstances in which the prosecutor, if I'm not wrong, may exercise discretion in deciding whether to start an investigation. When no suspect is expected to be staying in Germany, or in case of the complementarity condition. So, looking at the rationales of prosecutorial discretion in international criminal justice, in the absence of a nexus with domestic jurisdiction, a margin of prosecutorial discretion would be justified by the fact that national prosecutors could potentially be called to deal with over thousands of cases. By contrast, extending such prosecutorial discretion also to cases that do present a nexus with jurisdiction will be highly problematic, also from a criminal policy perspective. How would it be possible to justify why a prosecutor must start an investigation, for instance, into minor criminal offenses, for instance, in some countries, the criminal offense of irregular migration, while the same prosecutor would enjoy a huge, enjoy discretionary power in deciding whether to start an investigation into the most serious crimes as genocide, war crimes, and crimes against humanity. This brief definition of the scope of applicability of prosecutorial discretion at a domestic level brings me to the second consideration for our debate, the necessity of avoiding unfettered prosecutorial discretion that may foster the perception of politically motivated decisions. We are aware that the risk of political influence on the investigation and prosecution of massive crimes that generally involve political and military leaders is always very concrete and cannot be completely annulled, both at the domestic and international level. So which are the possible instruments to reduce this risk? Can judicial review, for instance, be effective in relation to this aim? And I'll try to address this in the final 3 or 4 minutes I have. I think that in this regard, both the German experience, but in particular the ICC practice, show the significance of a judicial review of a decision to start or not investigations and prosecution. If I understood it correctly from Thursday panel, when it comes to Germany, concerns were raised on the very limited scope of the judicial review of decisions not to start an investigation. I think Leonie raised this issue under Article 172 of the German Code of Criminal Procedure. Similarly, Andreas Schuller has also placed emphasis on the impossibility for the victim to complain and ask for a judicial review in light of very high procedural burdens, in particular of the fact that the victim has to present his or her own evidence within 1 month. But when it comes to the ICC, I will see mainly concerns arising from the exercise of prosecutorial discretion so far. The statute, just to be clear, does not establish any form of judicial oversight of the prosecutor's decision not to start an investigation, proprio motu investigation, under Article 15 of the statute. So far, the ICC overall practice shows that what is problematic in relation to this procedure is that generally, when following a generally long preliminary investigation, the prosecutor decides not to start an investigation, and this happens on the basis of contrived legal arguments, as occurred, for instance, in the UK-Iraq situation, in the Palestine-Israel context, in the Comoros situation, or when preliminary examinations are frozen for several years. This has fed the perception of a practice supporting a justice of the powerful, and this ambiguous exercise of prosecutorial discretion has also been one of the main criticisms that has prompted a legitimacy and credibility crisis for the court itself. Similar criticism has also been raised also in relation to the selection of cases, in particular to the prosecutor's choice to investigate crimes committed only by members belonging to one of the parties to a conflict, and turning a blind eye to the serious crimes committed by pro-government forces, for instance, such as in Uganda and our recall situations, or at the time rebel groups in Libya, and the very recent decision to deprioritize alleged crimes committed by US nationals in Afghanistan, mainly on the basis of a criterion which does not exist in the statute, which is the lack of financial resources. So, with respect to prosecutorial discretion at the ICC, together with the lack of a proper judicial review, we should also place emphasis on the ambiguous concept that have to be taken into account by the prosecutor in the exercise of these discretionary powers. I'm referring in particular to the concept of gravity and the interest of justice. Using the words of Professor Maigret, in this case, ambiguous concept as gravity may be used as a fig leaf for what is really a form of unaccountable discretion, one that basically, in his words, allows prosecutors to make dramatic decisions about the destinies of individuals and the future of nations without engaging in the politics that this should entail. So to conclude, exactly 10 minutes, with respect to the question I've been asked to address in this conference, I will leave to you this final thought summarizing these previous findings. A deviation from the legalité principle at the domestic level should be allowed only in exceptional when defined circumstances. I would say even more narrow situation than those enshrined in the German Code of Criminal Procedure, as far as there is an effective judicial review, and particularly of those decisions not to start an investigation or a prosecution, and this discretion should be exercised on the basis of clear legal parameters, conditions, concept, at least legal and non-ambiguous. Thank you very much for your attention.
Thank you very much, Triestino, for your comments and for also for staying in time. So I think we have time for a few questions, and the first question is with Judge Aitala, who wanted to ask a question. Thank you. Oh, sorry.
Thank you. No, my question is for Jerry. I was wondering, had Italy established jurisdiction on crimes against humanity? In your cases, did investigation bring about the existence of a widespread or systematic pattern, or in addition also a governmental policy, organizational policy? I was just curious whether if that jurisdiction had been established, you would have been able to prosecute proper crimes against humanity.
Of course, our approach was not to investigate crime against humanity. So I know something about that because also I worked at ICTY, so I have an idea about what can be considered a crime against humanity. In my opinion, the answer is yes, because considering what was happening in Libya, when you get thousands of people in some concentration camp, systematically torture them to get ransom for freeing them and send abroad. When you have a policy in certain part of Libya, you know, Libya is not a state now. I met at the time 2 or 3 times the general prosecutor of Libya, once at Eurojust, for example, and he told us, yes, we would be very keen to cooperate, but you know, I can give you something only about Tripoli, even if I'm called the general prosecutor of Libya, but I can't help you about Misurata, Zuara, Shabrata, or so on. So clearly there is a situation where, in my opinion, it would be necessary to investigate crime that can be considered a crime against humanity. This is the reason why, as I told you, we sign, as Teresa said, of course, ICC can't be part of a JIT, but we were able with ICC to sign this project that is not a JIT, but is a JT, so a joint team under Article 19 of Palermo Convention, just not to investigate, because we have different investigative powers, but we could exchange information and cooperation in a very different way, much easier way, much quick and speedy way. And in this framework, we share all the information we have about this crime with our colleague at ICC. And I have to tell you that the information that we have, in my opinion, are much more than the information that ICC have, but not because we are better, of course, but we have a first contact with these people. Before the pandemic emergency, there was a protocol that we issued, not only in Palermo, but in many prosecutor offices, to have immediately contact with the migrants, to interview them, get information, get a telephone number, social network profile, contact in Europe and also in Africa. So we had clear information. We had, for example, in my office, we had a distinction between the different area of Libya, making some sort of database for the information coming from there. So we share this information, but of course we stopped at a certain moment. Even if someone say that I think I have a universal jurisdiction, I'm not so egomaniac.
Yeah, thank you. Thank you very much. I see 2 further questions, perhaps 3 further questions. I think we hear the 3 questions and then come back to the panel and have a final round here. So please, Professor Bartoli. Is it working?
Okay, Giulio Bartolini, Roma Tre University. Thanks for the speaker, and I have one. Okay, again, thanks for that. I have one question for Mariniello, which is also related with the presentation by Judge Vigano, dealing with, so let's be pragmatic and practical, the way in which we could introduce potential reform dealing with the Italian system, and also with regard to the discretionary power of the prosecutor in this regard. So do you think it's feasible to introduce some limits in terms of also the tribunals who could be competent for international crimes in Italy? So one concern could be the idea that, of course, any prosecutor otherwise could have jurisdiction eventually, if you think about potential criteria of universal jurisdiction. In order to avoid this also very problematic approach, would it be possible and also practical, let me say, to attribute competence in any future reform just to one single tribunal, which could be, for instance, the Rome Tribunal in this case, which is also a solution already used, for instance, by Article 19 of the law dealing with military missions abroad, which attributes to the Rome Tribunal the only competence in this regard. This solution might have the advantage to both create some sort of specialization, potential specialization in Rome with some judge who could be also specialized in this area of law in order to, let me say, facilitate the quality also of the potential prosecution in this regard, and could also, of course, avoid this sort of showing approach that some prosecutor might have in different areas in order to start proceedings everywhere.
Thank you very much. Before you answer, Tristino, we will have the 2 other, if you would be so kind to be as concise and quick as possible. Thank you. Please go on.
So yeah, Luigi Prosperi, University of Amsterdam. I had one question for Dr. Mariniello, and eventually if Judge Aitala wants to also add a comment, I will be very happy. So you touched upon the issue of judicial review of decisions not to open an investigation based on the prosecutor's motu proprio powers, so under Article 15 of the ICC Statute. As you may know, last July, the ECCHR, on behalf of a victim and also with the support of Uprise, and here I disclose, at the time I was working with Uprise, so I was involved in this project. They filed a request to the prosecutor to reconsider the decision not to open an investigation into the Iraq-UK situation, and argued in the request that the prosecutor didn't correctly apply one of the admissibility criteria. Do you think a pre-trial chamber may or should be allowed to step in instances where the prosecutor actually adopts an interpretation that is not in line with the practice of the ICC in support of the decision not to open the investigation? And as the statute, of course, we know doesn't allow the pre-trial chamber to do that, what would be the solution? Like an amendment to the statute, an exceptional procedure? Thanks.
Thank you very much. And the final comment or question to Professor Vigano, and then we go on back to the panel.
Okay, let me come back once more to the question of mandatory prosecution, because I'm aware that prosecutorial discretion is already a reality, of course. And also I'm aware that one of the main tasks of Eurojust is precisely to solve possible conflicts of jurisdiction and decide who has to investigate and who has to put defendants on trial. But we are still desperately in need, I think, of a conceptual framework of explaining all this. So, I mean, it's a reality, but it doesn't mean that we have found the necessary conceptual explanation to reconcile all this with the principle of mandatory prosecution set forth in Article 112. And if we imagine a provision like Article 1 of the Völkerstrafgesetzbuch in Italy, that would mean that every provincial prosecution office having a notizia criminis should under a legal obligation to launch an investigation, to conduct an investigation, and then eventually verify whether there are the necessary preconditions for exercising the penal action. That means, for example, the presence of the suspect and or the request by the Minister of Justice. So, I mean, in the Sicilian case, it was different because the perpetrators were already there, the victims were already there, and that is, by the way, a reason why I am a little bit doubtful about the possibility of concentrating the competence in one in the prosecutor office of Rome, because if the perpetrators are in Palermo and if the victims are in Palermo, it's so much easier to conduct investigation there than it is in Palermo. So it's a complicated picture, but my point is we need a conceptual framework, and we need to work on it, because otherwise there would be a powerful objection, a powerful restraint from implementing the Rome Statute if we can't properly solve this point, I think.
Thank you very much. Now I think we have 3 minutes or so for the whole panel to reply, which is I'm sorry, but it's quite quick. So Tristino, you want to start because you were.
Yes, I will start with the last question, I think, by Luigi Prosperi. In relation to the UK-Iraq situation, I have to say I haven't read, maybe Chantal is in a much better position to answer to this question, but looking at the statute or the rules of procedure and evidence, my personal answer is, well, no, there is no possibility. As I said before, I called it unfettered judicial discretion. The statute does not provide the trial chamber to intervene, to exercise any judicial review when there is no state referral, when the prosecutor uses his proper motor powers. Is this a problem today, as we said? I think so. I think in Rome in '98, all the debate was focused on providing the prosecutor with the power, but then the discussion, the other side of the coin, was left completely unaddressed. I mean, the concern was when the prosecutor if we look at the preparatory work, so let's give the prosecutor with this power. That was the compromise following the proposal by Germany and Argentina, but you will need an authorization of the judges. But I mean, then the discussion did not address at the time what happens if the prosecutor decides not to open an investigation. In that case, there is no power for the pretrial chamber to exercise any judicial oversight. Of course, it's different, very briefly, when there is a referral of a state party. This is the pretrial chamber may intervene, but then there is a huge debate at the moment before the ICC, which is the power of the pretrial chamber, which is the standard of review that the chamber can apply in this regard, and whether the decision is binding or not. An amendment should be taken into account, even if I don't think it's feasible, it will happen, should be taken into account, looking at the practice of the court in these 19 years now, more or less, yes. So very briefly, going back to the other question, well, of course, this is a killer question. Is that feasible, I mean, to provide this competence to one tribunal? In order to address this question, what I will do personally is to look at the other domestic experiences to see how they have ruled, as I suggested at the beginning, the powers of the prosecutors. And of course, feasible means whether this is a problem of financial resources, of personnel, and the answer at the stage could be yes, following, this could be feasible, following, but just in very exceptional circumstances, as I said before, in those circumstances in which there is really no nexus with the state party. In that case, I was sure that the state would receive hundreds of thousands of cases to investigate. That's the question, of course, I'm raising. So sorry for maybe.
Thank you very much. So Judge Aitala, you want to?
Well, very briefly, if you don't mind, I will not answer directly to your question. I will just highlight 3 possible legal mechanisms. One that we have in Italian law is that complainants, when the prosecutor decides to drop the case, can trigger a review of a judge. This is the first possibility. Of course, this would call into question who are victims before the ICC. It's a long story. I won't touch upon it, but complainants, probably it's a bit more specific. You bring in a complaint, the statute says that they should be informed. It could be added that then if they disagree, then the chamber may have a say. That's the first possibility. Second is the timing, the scope, the quality, the speed of an investigation is inherent to any prosecution. We know very well. So regardless of any legal mechanism, any prosecution gives investigations a certain rhythm according to resources or ideas. The only possibility is providing for timelines. But it's very difficult in international criminal law. It's very difficult to imagine that you can give a timeline as we do have in national legislations. Third, judicial review. I would simply say that very often judicial review is seen in a confrontational manner. That is, you know, they say activism of the judges against. I mean, judicial review, it's a guarantee for everyone. It's a guarantee for the court, for victims, for the prosecution. I mean, I have been a prosecutor and I never felt diminished by having to bring my charges or my decision not to charge before a judge. I felt guaranteed to the contrary. So I think that this is the matter. And I will conclude by, I see that David Donat-Cattin, who's a friend, by the way, is asking whether it would be possible to establish like pre-established criteria. I think that this does not work. You cannot, I mean, this idea, it has never worked. Even when the prosecutor's person itself, they prepare these policy papers, they just don't work. You cannot see in advance pre-establish how life will go, because the reality is always too difficult and too articulated to be foreseen in advance. Thank you.
Thank you very much. And thank you also for including the question I just saw here on the screen. And the final intervention. Yes, welcome.
I will be very, very brief. So I do understand the concerns of Professor Vigano. I fully share them, as I share his thoughts regarding the unfeasibility of a kind of exclusive competence of certain tribunals. Yeah, but this is a topic we have to address. We have to address it in a practical way so that we can find a kind of minimum common denominator to solve it. I know it's a huge block. I'm fully aware of it, but it's something, it's a pillar of our system. We do not want to demolish it. So we have to find solutions to live with it. So yeah, I knew you agreed.
Okay, before we, Chantal, if I'm correctly, if we immediately change seats, please remain seated, everybody. There will not be no break. We will immediately go on with the final concluding round table. But so before we change seats with the concluding panel, let me thank again to all the panelists and for the interesting and thought-provoking presentations. And we may have a chance to go on bilaterally on that. But yeah, thanks a lot again. Thank you very much.